That's the law. All
Okay,
right.
sir.
So
So, but
learn to live with it.
that's
Mhm.
that's a clear abuse of power. I've been up here for 150 days, and I've asked my clients, or not my clients, my attorneys, to please represent me in this matter, and they have not done it. And they can't give me a reason. They can't give me a KSA. They can't give me any of that. I've been up here for 150. This is an abusive process.
If you don't like it, go hire your own lawyer. Okay? That's your choice.
I'm not asking that. I'm not asking them to
No,
withdraw.
no,
I'm
I'm
asking you
done.
to rule
I
on
am
the
denying
procedural
the
timeline.
motion to withdraw,
Will you
and I
rule on the
appreciate.
procedural timeline error?
Okay. Jailer, put him on mute.
Today's hearing features a defendant whose behavior is already drawing attention for all the wrong reasons. From the very start, he shows clear disrespect toward his own legal team, and the judge isn't allowing even a moment of it to go unchecked. The case itself is extremely serious. He is being accused in connection with the tragic death of his 5-month-old daughter, and prosecutors allege that harmful substances were found in her system. As a result, he is now facing a major charge, second-degree murder. Today, as we go through this hearing, I want to know your thoughts. Do you believe he has any valid point in what is arguing? Or is the judge completely justified in shutting him down immediately? Let's get into it.
Your Honor, Mr. Leon appears by Zoom and through counsel, Christopher Rourke Colby and Cassie Ziegler of Ellis County.
All right, Mr. Leon, do you have any objection to us conducting this hearing by Zoom?
No.
Very good. This before the court on the defense counsel's motions to withdraw. And those were recently filed as of actually yesterday, and both counsel asked for an emergency hearing or as early as possible. Mr. Leon, are you ready to proceed on your counsel's motions to withdraw?
I am, sir. And then I'd like to address the courts if that's okay.
Well, we'll see. Let's get to the motions first with the attorneys. Besides what's in the motion, is there anything additional that either attorney wants to present?
Your Honor, I think that the only thing, anything additional I present, I think given Mr. Leon's, I think behavior, demands, threats, his actions, going through with those threats, I think the trust between the attorney and client's broken, and I don't know how you fix that.
Okay. Ms. Ziegler, anything additional besides what Mr. Rohr said?
No, I totally agree with Mr. Rohr, and I don't think I have anything else, Your Honor.
Okay. Ms. Leon, I will now invite your comment. Leave it strictly to this motion to withdraw. Nothing else about the case, because that's not what's before us today. You understand?
Yes, sir. I do have, yes, sir. So,
okay. Regarding the motion to withdraw, do you wish for these two attorneys to withdraw?
So I've asked my attorneys to file a motion multiple times on a procedural timeline error of not having me into a preliminary hearing within 14 days. This right is guaranteed to me per the state statute 7.2 and supported by my 4th Amendment right to due process and incorporated by my 14th Amendment due process clause. State versus Fink does guarantee the defendant the right to be within a preliminary hearing within 14 days. And I've asked them both to file these motions. Neither one of them are filing these motions. And I would ask the court to consider these motions as well as, I haven't asked them to withdraw. They said I've just asked them simply to do something. Your Honor has already ruled on this and told me that he was not going to allow them to withdraw because of the state's short amount of attorneys that can handle these cases. So I have not asked them to withdraw at all. I've simply asked them to invoke and enforce or ask the courts to enforce my right to due process in my 14th Amendment due process clause because there is a procedural timeline error, and they continue to try to dissuade me from bringing this to your attention, saying that it's not correct. But I have the state statute pages right out of the book that an attorney has sent in that does guarantee me these, says that it does guarantee me the right. While it's not, preliminary is not, like mandated, it's not constitutional. But in that case, I would then need to be to an arraignment within 10 days. I've not waived that right, and my attorneys, I've brought this up to them multiple times. Cassie hung up on me once when I was trying to talk to her about it. Mr. Rohr has said that he was going to bring the issue up to you, and then next thing I know, he was telling me that the next thing I know, I'm getting a motion saying that you guys are going to withdraw. They're trying to withdraw counsel. I didn't ask them to withdraw. I took your ruling on the matter last time seriously, is that you were not going to let them withdraw. I'm not asking that they withdraw. I'm asking that they represent me to their fullest of capabilities in this matter of my
This defendant is in court for an extremely serious case, yet is acting like he's got everything under control and doesn't need anyone's help despite having two experienced attorneys right beside him. He keeps jumping in and trying to speak as if as a lead strategist, the confidence he displays almost makes it seem like he's been practicing law his entire life. But let's be honest, it's more performance than expertise. It's obvious he understands the evidence is stacked heavily against him, and that's likely why he's scrambling for any possible angle. At this point, he's firing off arguments rapid fire, hoping one of them lands, which is a classic sign of someone running out of options. There's a major difference between using a defense strategy and completely ignoring the professionals who are literally there to protect you. What makes it even worse is how he keeps interrupting and talking over his own attorneys in front of the judge. That doesn't just make him look difficult, it can make the court far less willing to take anything he says. Seriously, public defenders may not always be flashy, but they understand courtroom procedure far better than most defendants ever will. The more he pushes back, the clearer it becomes as either refusing to accept reality, or he genuinely believes is the smartest person in the room. Curious to hear your thoughts. Do you think this is desperation, or does he truly think he's outsmarting everyone involved?
Mr. Leon, your basic argument with your attorneys right now is that you want them to file a motion to dismiss your cases for failure to bring you to preliminary hearing within 14 days, correct?
That and there are other matters, sir.
Okay. Well, that's what you started with. Let's just begin
Okay.
with. All right.
Okay.
Your attorneys both know the law. Now, you've noted the statute 222902, okay? But they also know the law. State versus Weigel, the Kansas Supreme Court ruled in 1980, quote, the time limitations in 222902 are directory and an inconsequential delay beyond the time specified for holding a preliminary hearing will not justify a dismissal. That is the law in the state of Kansas. It has been the law since 1980. It has not changed. And so your attorneys are aware of that, as is the court and the prosecutor. They do not have an obligation to file frivolous motions. And so your argument with them is that they won't do what you direct them to do, and that is not their responsibility. I explained this to you before. How an attorney handles a case, the strategy is their decision, not yours. You have input, they will listen to you, they will incorporate your thoughts, but they will do what they believe is in your best interest under the law. They are not there to do what you tell them to do. Rather, they're there to represent you zealously and as advocates within the ethical boundaries that are set there. That's the rule. So
But
you can
you're-
sure tell them, I would like you to file this motion because I think it's a violation. And they would say, well, we understand you read it that way, but it's already been in front of the Kansas Supreme Court and they disagree with you. And that's the highest authority in this state. So,
But Your
Well,
Honor,
file the motion.
State versus Fink says that I have this. Hold on.
yet I'm telling you, Mr. Young, I'm not going to have a legal debate with you, okay? I'm telling you, I gave you the case citation. It is not the only Kansas Supreme Court case that is ruled on this issue. It is directory, not mandatory.
I understand
is
that,
the
sir.
law.
I've been up here for 150 days without a preliminary hearing or any type of court proceeding. That's a clear abuse of power.
Well,
or
that's a
abuse of
different
process.
argument, and
This is-
we're not gonna, I told you we weren't gonna get into that. We're here to talk about whether I'm gonna let your attorneys withdraw or not, okay? But I wanted to give you at least the law to explain why they don't do everything you ask them to do.
Your Honor, that doesn't tell me anything about the procedural timeline error though, that I've been asking them to represent me on. The procedural timeline error does say, Your Honor, that an abusive process cannot be done. I've been up here for 150 days and I've asked my clients to please represent me in this, or not my clients, my attorneys to please represent me in this matter, and they have not done it. And they can't give me a reason, they can't give me a KSA, they can't give me any of that. And it also says, Your Honor, that I am entitled to being into a preliminary hearing or an arraignment within 10 days. I've been up here for 150. This is an abusive process.
Okay.
This isn't.
I've listened to this before. This is what we're here for today, is your attorney's request to withdraw. Here's what the court's going to hold. You can keep filing ethical complaints on them. You can keep doing whatever, all of these pro se filings. I mean, you have a lot of time on your hands up in jail. So I'm not in any way telling you that you're prohibited from doing that. But they will control the strategy and the procedure in the representation of you. And here's the bottom line, Mr. Leon. I could appoint every attorney in the state, and they're going to have the same problem with you that these two attorneys do. That's the criteria I have to look at. Okay? If you don't like it, go hire your own lawyer. Okay? That's your choice.
Yeah, the judge knows exactly what this guy's trying to pull here, and it's just not working. He tries to lean on state versus Fink, as if it's some magic key to freedom here, but it doesn't override Supreme Court precedent. He's been in custody for 150 days without a preliminary hearing, but there's a reason for that. Serious felony cases often take months to build because of the evidence review, witness prep, and scheduling stuff, so when you're facing decades in prison for causing the death of a child in your care, you're not exactly a top priority for a speedy release. And he's also acting like the system owes him a fast pass to freedom here. But in reality, he should be using this time to work with his attorneys instead of fighting them. Public defenders are one of the most important tools in our legal system. They give people without resources a fighting chance. And here we've got a perfect example of someone who doesn't respect that at all. The court's patience isn't infinite, and the more he pushes, the closer he gets to burning every bridge he has left. I mean, this is what happens when arrogance outweighs strategy, right? Do you guys think he even understands how bad this is for him? Or is he too focused on being right to see it?
But if you can't hire a lawyer and you apply to the court, you're going to live with and deal with the competent and qualified lawyers that the court appoints for you. That's the law. All right?
Okay, sir.
So learn to live with it and learn to cooperate with him, because I'm not going to let him withdraw, because if I do, the next lawyer I appoint, I'm going to have the same argument. And here's the other thing, Mr. Leon. Your main argument is, Judge, I've been up here 150 days. I want my day in court. If I appoint a new lawyer, they're going to have to review all of the discovery in this case. They're going to have to interview witnesses. They're going to have to communicate with the prosecutor. They're going to have to visit with you. That takes time. And that you're not the only client they have. So that time is longer. So the very thing you're complaining about, if I grant the request that they're making on your behalf today, only increases that very time standard. The very time problem you're talking about. It's counterproductive.
I understand that.
I'm
not asking that. I'm not asking them.
No, I'm done. I am denying the motion to withdraw at this time.
Will you go on the procedural timeline error?
Okay. Jailer?
Yes, sir.
Put him on mute. I'm not going to have him interrupt me anymore. Thank you. Counsel, I just wanted to express to you that I appreciate the dilemma you have. It's not the first time you have gone through something like this. I'm denying your motions at this time for the reasons I recited. Number one, any other lawyer I appoint is going to have the exact same problem. I'm just going to keep repeating it. And number two, if I appoint new counsel, it's going to further delay the hearing, and we already have a preliminary hearing scheduled. And I'm not going to delay it another 100 days or 150 while a new attorney gets up to speed on the case. This defendant's complaining that he wants to get into court. We're going to give him that because it's scheduled, and we're going to go forward with it as scheduled. Understood?
Yes, sir.
Yes, sure.
Very good. Okay. Anything else that you need to address with the court today?
No, you're
No.
understanding.
Very good. All right. We are scheduled for preliminary. When is that again?
Next week.
Next
Wednesday.
week.
The 14th, 13th. It's the 13th.
Yeah, I knew it was coming up. I knew it was next week sometime. Let me look here. Yeah, we're scheduled for an all-day preliminary next week, Wednesday, a week from today. So, since Mr. Leon's main complaint is, I want to get my preliminary, we're just going to get it a week from today. And if we hire or if we appoint new counsel, it would be delayed probably well into January or February next year with the holidays and the scheduling problems. So we will give him what he wants. I will expect that you will visit with Mr. Leon about his conduct in the courtroom. In other words, that he is not to interrupt either the judge or witnesses, that he's to listen to the evidence, that if he needs a recess to visit with you, the court will accommodate that and allow you to go into chamber or into the conference room to do that. I know he's listening to this, and I'm hoping he's paying attention, because I will not tolerate the kind of conduct that we had exhibited today, where he continually interrupts and continues to repeat the same arguments. So he's going to get a preliminary hearing as he desires, and it is a week from today. And with that, we will be adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
The judge is clearly aware of what this defendant is attempting, and none of it is landing the way he hopes. He keeps bringing up State v. Fink like it's some secret legal loophole that guarantees his release, but it simply doesn't outrank Supreme Court precedent, and the court knows that Dodd has been in custody for around 150 days without a preliminary hearing. But there's a valid reason for that. High-level felony cases, especially those involving the death of a child, require extensive evidence, review expert coordination, and careful witness preparation. These are not cases that move overnight, and the court isn't going to rush simply because the defendant is impatient. The problem is, he's acting like the justice system owes him a quick exit. Instead of working closely with the attorneys assigned to defend him, he continues to resist and undermine them, and that's a huge mistake. Public defenders play a crucial role. They protect the constitutional rights of people who can't afford private representation, and many of them are exceptional at what they do. But what we're seeing here is someone who doesn't seem to respect that at all. The court's patience is not unlimited. The more he challenges the process, the more he risks making his situation even worse. This is exactly what happens when ego replaces strategy. So what do you think? Does he truly not realize how damaging this behavior is, or is he so determined to be right that he can't see the consequences closing in on him? School. At this point, it's hard to understand why he's still trying to push back against the process. It really feels like he's just buying time, delaying anything he can, because he knows what's coming once this reaches trial. And the reality is, prison might actually be a step up from county jail. State prisons generally have more structure, better resources, and access to rehabilitation programs that simply don't exist in short-term holding facilities. But let's be honest, this is not a minor case. He's being charged in connection with the tragic death of his 5-month-old daughter while she was under his care. And according to the prosecution, dangerous substances were allegedly found in the child's system. That's a level of severity you don't just argue your way out of. There's no quick technical escape from something like that. In situations like this, complaining about discomfort or delay doesn't earn sympathy. It only reflects badly. This is a moment to cooperate with counsel, not fight them. Because if it were up to many people, watching a case of this nature would receive the harshest possible outcome with no second chances. So what do you think? Is he genuinely convinced that his attorneys aren't working in his favor? Or is this just a strategic stall from someone trying to avoid the inevitable? Thank you all for being here. Your support means a lot. Don't forget to like and subscribe. And I'll see you in the next breakdown.